This is Jason Leopold with Truthout. Paul Charlton is a former U.S. attorney for Arizona who was fired last year along with 7 other U.S. attorneys for reasons that appear to be politically motivated. Recently, he testified before Congress to describe the pressure his office came under to pursue a death penalty case. I spoke with him immediately following his testimony on a wide range of issues resulting in his firing. Paul, thanks for being with Truthout. Recently, you testified before Congress on death penalty issues, and from what I have gathered from the testimony, you said that Alberto Gonzales, the Attorney General, was overzealous in pushing death penalty cases. Can you elaborate a bit on that, and specifically the case that you were discussing before Congress?
Probably the easiest way to talk about it is to make reference to that one case that I talked about, Jason,
Sure.
And that is in the case of United States versus Rios Rico. It's a case in which a methamphetamine dealer is alleged to have killed his supplier. And the evidence that supports the government's prosecution is largely based upon the testimony of other individuals who have cooperated, pled guilty, and agreed to provide testimony against Mr. Rios Rico. That's sufficient evidence, in my opinion, to go forward with the case, to seek a conviction, and in the event of a conviction, seek a sentence for a term of years or life. But what removes that case from the realm of a death penalty case is its lack of forensic evidence. That means there's no gun, there are no ballistics, there's no victim DNA on the defendant, no victim or no defendant DNA on the victim. In fact, what makes this case all the more troubling is that there's no body. That in and of itself is, to me, sufficient because of the lack of forensic evidence. The quality of that evidence means that you should not seek the death penalty. The first I heard that my recommendation had been ignored was when I received a letter from the Attorney General, and they use this very euphemistic term. They say you're now authorized to seek the death penalty, which in reality is an order to seek the death penalty.
Authorization is the word that they use, but essentially what they're saying is you're ordered to
Correct.
do that. Okay.
So I contacted the Office of the Attorney General, the Office of Deputy Attorney General, the Assistant Attorney General in charge of criminal, to try to reverse that decision. And I was unsuccessful in the end. But the part of that conversation that was most memorable for me was the conversation I had with the Deputy Attorney General, Paul McNulty, in which I, in greater detail than you and I have discussed here, talked about the facts and why I felt that you could not in good conscience seek the death penalty here.
So what was your conversation with Paul McNulty then after you received the order to seek the death penalty?
Well, he and I had a discussion about these facts, and then he said he would visit with the Attorney General about it. And I then heard back from McNulty's Chief of Staff, Mike Elston.
Mike Elston.
And Elston told me that McNulty had his conversation with the Attorney General, and McNulty wanted me to be aware of 2 facts in particular. The first was that McNulty had spent a significant amount of time with the Attorney General on this issue, perhaps as much as 5 to 10 minutes.
5 to 10 minutes. That is what's considered significant, the Department of Justice.
That's how it was relayed to me.
Okay.
Then the second point was that McNulty wanted me to understand that in the course of his conversation with the Attorney General, he had remained completely neutral. He had neither supported nor critiqued my position. And that surprised me as well, because on this decision, whether or not you should intentionally and methodically seek to take another person's life, neutrality has no place.
Right.
I would have preferred that he had said, I don't agree with Charlton. We should seek the death penalty in place of someone who was going to take no position at all.
Do you believe that your firing had anything to do with the investigation into Congressman Rick Renzi, or any investigation or preliminary investigation into Jim Colby?
When this first started to come to light, when I started to explore, and others did as well, why it is I was asked to resign, I would have told you with some degree of certainty that it must have been my disagreement over the death penalty and my insistence that the FBI tape confessions. But as I've listened to the testimony of senior leadership at the Department of Justice, as I've read the transcripts, as I've done interviews with those individuals who are investigating those people at the Department of Justice, as I've looked at the emails that have come out, I've come to the conclusion that I'm not certain if those in fact are the reasons. Those are the reasons they proffered, Those are the reasons that they give. But I'm not certain myself whether or not those are the genuine reasons or they are reasons more of convenience.
What are some of the questions that you were asked by the Inspector General at the Department of Justice? You were interviewed by that office. Was there another office, another internal investigation?
OPR was there as well.
That's the
Office of Professional Responsibility and the Inspector General.
What was some of the issues that took place?
Well, that's another aspect, I guess, of my training and experience as a prosecutor. And I know that while no one would ever instruct me not to share what our interview was about, and I would never have done it as a prosecutor either, and I'm glad they didn't because they're being very professional, it's best not to share what it is you've been asked about.
Can I ask you then if you've, during the interview, if you learned anything new?
I came out with new information, and that information only further solidified my belief that we need to continue this investigation, that it's unclear whether or not the two factors that they've testified under oath were the genuine factors for my being asked to resign. And that's what I came away with.
And in terms of where this investigation is headed, is there any crimes that appear to have been committed here?
Well, again, it's so early on.
Okay.
It'd be premature for me to say that I've seen probable cause or any other quantity of evidence that would justify calling this a crime at this point in time. But I can say that at some point in time, the Inspector General is going to need to, and whether or not he's at that point yet or not, analyze the evidence that he has at a certain date and determine whether or not a special prosecutor needs to be appointed to assist them in this investigation.
Special prosecutor. And in terms of Rick Renzi, how did you come to first investigate him?
Well, that's not a public record at this point in time. There will be a time, I'm convinced, when it will be a public record. And as I've said before to others, the chronology of this investigation will be made public. And I think that'll serve to answer a number of questions about the relationship with Mr. Renzi. And we just have to wait until that information comes out in the public.
Well, news about this investigation leaked out. How do you think it leaked out?
I don't know. Again, I think I have some theories and some ideas. No, because I haven't developed those to the degree that I'd feel comfortable giving to you them as facts.
Okay.
There's speculation, and I have ideas, but I really can't give you any facts.
You also discussed the fact that you received a phone call from Michael Elston, and there was a quid pro quo. Can you describe the details of the phone call?
Elston called to say, we've noticed that you haven't been speaking to the press, and at that point in time, there wasn't any reason to speak to the media. It was still unknown that I'd been asked to resign. I thought that the appropriate way for me to handle this issue was to go out as a good soldier. They wanted to put somebody else out here, that was fine, and I understood that that was a prerogative of the president's. He commented on that fact. He indicated he wanted me to know that the Attorney General wasn't going to speak on anything. And did I have any questions about that? It was clear to me, and I suspected that what he was telling me was, look, the Attorney General's not going to say anything. We don't want you to say anything. And if you want to continue with the storyline that you haven't been asked to resign, then that's the best way for you to handle this. When I spoke to John McKay, and he had almost a word-for-word conversation exactly like mine, and his conclusion was the same. It bolstered my opinion that that's what Elston was doing. And then finally, when Elston had his conversation with Cummins, and Cummins shared that email with the Senate that he drafted to us after his conversation with Elston, in which Elston clearly threatened us and others with coming forward with information relating to why it is we were asked to resign, it was made crystal clear to me that Elston was threatening us. And I know from my experience as a prosecutor that when you attempt to intimidate a witness, you never, even the least intelligent thug from the least sophisticated organization knows that you never go to a witness, a prospective witness, and say, look, if you testify, you're going to get hurt. What the least intelligent thug will say is, look, we know where your family lives. Or, I understand you're about to testify, here's a picture of you that we got from you getting out of your car this morning. You don't have to say anything more than that. And I understood exactly what the message was.
Charlton is now a partner at Gallagher & Kennedy in Phoenix, Arizona, where he is working on Indian country issues. This is Jason Leopold reporting for Truthout.